Welcome, everyone. I am absolutely thrilled to be guiding you through today's explainer. We're going to be breaking down a truly fascinating area of jurisprudence, the law of persons. Now, since we're covering units 6 through 20 today, we're going to take this at a really measured, comfortable lecture pace. Not too fast, not too slow. I want us to really absorb these concepts that determine a person's legal status in the real world. Also, just a quick note before we start, we do have highly legible subtitles available throughout this entire lecture for anyone who might need them. Okay, let's dive into this. Here is our roadmap for today. Number 1, defining legal status. 2, domicile, which is the law of place. 3, unmarried parents and status. 4, age, specifically looking at infants and minors. And finally, number 5, diverse factors limiting capacity. Starting off with Section 1. Defining legal status. This covers Learning Unit 6. Before we can explore what limits your rights, we really have to define what those rights actually are. And that brings us to a foundational quote from the Heaton textbook. Let's read this deliberately together. The law of persons is that part of private law which determines which beings are legal subjects, when legal personality begins and ends, what legal status involves. As Heaton points out here, private law is effectively our first law. It's the primary sphere of law governing our daily, everyday relationships with fellow human beings. Everything else out there, constitutional law, criminal law, it all builds right on top of this foundation. And this brilliantly illustrates exactly where we are in our curriculum today. Notice how the scales of justice map out parts 3 of our study guide. We are focusing squarely on the specific, real-life variables that determine status. From Learning Unit 6 all the way through to Unit 20, we'll see exactly how different human conditions actually tip these scales. Right. So when we talk about status in the legal sense, we are really talking about a matrix of 4 distinct competencies. You need to grasp these 4 pillars. First up is legal capacity. Second is the capacity to act. Third is the capacity to litigate, meaning your ability to sue someone or be sued yourself in court. And fourth, accountability for crimes and delicts. Delicts, by the way, are essentially civil wrongs. Your overall legal status is literally just the sum total of where you stand in relation to these 4 specific pillars. Let's look a bit closer at the first 2, because honestly, they're the ones that usually cause the most confusion. There is an absolutely crucial difference here. Legal capacity is simply the capacity to have rights and duties. Literally every single human being, from a newborn baby taking its first breath to a 90-year-old adult, holds legal capacity. But the capacity to act is the ability to actively perform a valid juristic act, like signing a contract to buy a house or a car. So while every human has rights, not everyone has the capacity to actively perform valid legal actions under the law. Think about it. A 1-year-old baby absolutely has the right not to be harmed, right? But they obviously cannot sign a legal lease agreement. Moving on to Section 2, domicile, the law of place. This brings us to Learning Unit 7. So what is domicile? It's essentially the law of place, the geographical factor in the law of persons. Because legal systems differ wildly across different regions and countries, the place where you legally live fundamentally dictates the extent of your legal capacity. It determines which specific system of rules applies to your life, whether and to what extent you can litigate, and exactly how you're held accountable. If you cross borders and completely change your domicile, the very nature of your legal standing might shift dramatically based on that new jurisdiction's laws. Section 3. Unmarried parents in status, covering Learning Units 8 and 9. Here's where we explore how the circumstances of a child's birth alter their legal standing. The law assigns parental responsibilities and rights a bit differently based on real-life scenarios. For instance, the legal status of a child born to married parents traditionally differs in certain administrative and legal aspects from a child born to unmarried or single parents. The law also relies on what we call presumptions of paternity. That basically means legally assuming a husband is the father of a child born during a marriage, and it outlines exactly how someone would go about legally proving or disproving that biological fact. And it's really fascinating because the law continues to evolve to cover modern scenarios too, like artificial fertilization, making sure a child's legal status is protected no matter how they came into the world. Section 4, age, infants and minors. We are shifting now to one of the most universal factors affecting capacity out there, referencing Units 10 through 19. Let's move to and see how this builds as we look at Learning Unit 11. Here we examine the absolute most restricted age category in the entire law of persons, the infants. This is a young child, typically under 7 years old. Let's compare the infants to an older minor, just to put this into perspective. An infant has an absolute total lack of capacity to act.
They cannot form legally binding agreements, period. End of story. A minor, on the other hand, let's say a 16-year-old, well, they have a limited capacity to act. They can engage in some juristic acts, but they strictly need the assistance or the later ratification of a legal guardian. There are a few statutory exceptions out there, but generally speaking, a 16-year-old signature all by itself just isn't enough to legally bind them to some massive financial obligation.
Now, you might be wondering, what is the point of all this? We need to ground this academic principle in everyday reality. Why does the law actually do this? Is it just to punish young people? No, not at all. The entire purpose of this limitation is the strict protection of youth. The law intentionally restricts young people's legal status to protect them from the consequences of their own immaturity. It's literally there to prevent a teenager from making a ruinous legal decision that they just don't fully understand yet. Section 5. Diverse Factors Limiting Capacity. Bringing us to our final unit, Learning Unit 20.
So the crucial point is that simply attaining adulthood does not guarantee unlimited legal capacity forever. Extreme life circumstances can step in and strip away an adult's capacity. We're talking about specific, incredibly difficult human conditions: mental illness, a physical or mental inability to manage one's own affairs, intoxication, prodigality, and insolvency. Any of these can temporarily or permanently alter your legal standing. Let's take intoxication as a highly relatable example straight from the text. Now, we all know there are strict rules of conduct against driving a motor vehicle on a public road when intoxicated, but in private law, if you are severely under the influence of alcohol or drugs, the law states you simply cannot form a valid legal intention. Therefore, extreme intoxication temporarily nullifies your juristic capacity. If you sign some complex business contract while completely incapacitated by alcohol, the law may view that act as completely void.
Similarly, let's look at insolvency, which is essentially severe financial ruin. If a person's estate is legally sequestered due to insurmountable debt, their legal status is fundamentally changed. The law literally steps in and dictates what they can and cannot do with their own property and assets in order to protect their creditors. Your financial state, therefore, directly limits your capacity to act.
Finally, we look at prodigality. This is a situation where a person recklessly squanders their wealth. They can legally be declared a prodigal and completely stripped of their capacity to manage their own money. But I want to leave you with a really provocative question drawn directly from our study guide to end today's explainer. Are the limitations that are placed on interdicted prodigals unconstitutional? Think about it. Does taking away a person's right to spend their own money, even if they are doing it recklessly, violate their basic human rights? Or is it a totally necessary measure to protect their state and their family? It's a really delicate balance between protection and liberty, and it is exactly the kind of deep, critical thinking the law of persons demands from us. Thank you so much for joining me today. I really hope this helps solidify these real-world concepts for you. Keep pondering that final question and keep learning.